How's it going, Your Honor?
Hello, Mr. Suarez.
Hey, could I get your number, Your Honor? I got to send over some pictures, as well as I'm sending them over to Fez as well. But if I can get your number.
Right, are they already evidence that he's in the docket at the moment?
It was on the bench trial. It was presented as evidence in the bench trial, but it never got into the actual docket itself since it was a small claims court.
Okay, give me a moment. You can motion at the start of the case to have them added, and
Okay.
then we'll work on that.
All right, no worries.
Which one of you wants to go set up with Aristotle?
Give me one moment, folks, and we'll be ready to go.
I don't know what I would be doing up there.
Dalton?
Sorry, Dalton.
Why'd you have to set up though?
I'm just waiting for my clerk of the court. Here he comes.
I don't know.
You don't want your number.
That's handy.
I'm sorry, did the clerk say there was a transcript for the previous hearing?
No, I'm just, unfortunately, the MDT doesn't allow me to use the links to get to the other parts of the judgment. So I'm asking him to find it on the docket for me. I know it was put on the docket.
I could tell you which docket number that is.
Oh, that would be helpful.
That is, let me see here. Number 28.
3.
I appreciate that. Thank you, Mr. Bardin. Right. I am going to call docket filing number 43 into order. Appeal of civil judgment Lorelei Love versus LSPD. First things first, do we have any pre-trial motions from the plaintiff?
Well, your indulgence, Your Honor. Seeing as none of my witnesses bothered to make it to court today, I don't think that the state has much need for a long hearing today. I think if I could just make my motion to dismiss as my opening statement, then we could have analysis of the evidence, and then the defense can make their case, whatever that may be, and then we can allow you to deliberate on the issue. I mean, if that's agreeable to counsel as well.
Respondent, are you agreeable with that?
Well, as far as the motion to dismiss,
It's just going to be my argument.
Okay, yeah. Well, we
He's
definitely
basically making his argument in the motion. I'll give you a chance to respond, etc. We can go from there.
You mind speaking up, Your Honor? Sorry, I didn't hear what you said.
I said he'll basically make his motion and give me his reasons, and then you'll get the chance to respond to it at that point.
Sure. Yeah. We have no problem in him making any motions and us responding, Your Honor. That's perfectly fine.
Okay. Would you like to make that now, Mr. Bardin, or would you like me to wait to see if the defense have any motions?
Yeah, let's see if they have any motions.
We just wanted a motion about the evidence, Your Honor, that I mentioned a second ago. I have all the stuff ready to provide to Mr. Fez and you yourself, Your Honor. That's why I was inquiring about your phone number. All this evidence was already admitted in the small claims court, but since it was small claims, nothing really went on the docket. So, but I'm happy to send over all the evidence.
Put this evidence on the actual docket itself, number 43. Are you able to input it there?
I can put all the links on there if you would like it that way, Your Honor, or I can text it. Which one would you prefer?
It would make it easier putting it on the docket. It makes a record of it for a start.
All right.
Barney, do you have any objections to this evidence being added to the docket?
No, I requested this evidence, so
Wonderful. Perfect. Yes,
I'm
please
happy
go
to have
ahead.
it.
All right. Yep. Let me just throw them in now.
I will give you my number afterwards, Mr. Suarez. Don't worry.
It's all right. I get it, Your Honor. You just don't want my number. It's all right.
Well, you know how it is.
I guess the only thing that I would move for, in addition to this, would to add the criminal proceedings to the whole record of that as evidence as well.
Okay. You'll have to refresh me. Which one were the criminal ones? Was it the judicial panel?
The panel and then the original case. I can find those real quick and give you the numbers.
Yeah, can you just pop them on the record if you can? If you don't mind, just pop a list of them so I know what they are.
All right. Your Honor, all the photos are on the docket.
Okay. We'll just let Mr. Barding to pop the references that he wants on there as well.
Were we asked to do something or no?
No. I don't think so.
You see the photos?
Yeah, that's
Yeah.
good. I think we need to argue that the criminal trial is separate from this one.
Yeah, that it was completely after. I'll try to. I'll make it. I'll make it very
We'll
blunt.
see.
So what are we waiting on right
Waiting
now?
for. I don't know. Do you have an opening?
Yeah.
I was unable to link them conveniently, but I noted that they are dockets 30 and 31. For your honor.
Okay, I'll pull those up for now. 1 second.
I gotta check on my food. BRB.
All right. Yep.
Right, lovely. I believe that is all evidence requested to be added. I have those 2 dockets up as well. So let's start with your motion, Mr. Barding. You'd like to go ahead and make your argument.
Thank you, Your Honor. The state moves to dismiss the civil claim for administrative negligence with prejudice in this matter. This motion is primarily grounded on the fact that there's newly established criminal record, that the criminal appellate court has upheld a guilty verdict, and that Ms. Love knowingly impersonated a government official and acted with fraudulent intent. This criminal finding renders the civil claim kind of legally untenable in this matter. The civil judgment previously relied on the theory that Ms. Love was the victim of an administrative error and it was unnecessarily detained before ultimately being released. Those are the judge's own words. Due to an incomplete warrant. The criminal record now proves that Ms. Love is a liar, first, and her detention and processing were the result of her own knowing deception, and that there is no state negligence that caused her injury. it's only her own fraud that did that. The victim narrative is a claim that contradicts what Love actually did. The lower court awarded damages based on the premise that Ms. Love was an innocent party caught in an administrative web or bad faith warrant writing. However, the criminal appeal court ruled that she is, in fact, a fraud. The plaintiff sued the respondent.
Jesus, I thought this was going to be a simple case. Faz is writing a whole fucking opening statement.
This is, they should have essentially. Los Santos doesn't recognize qualified immunity when it comes to officers, so the proper remedy for this actual misconduct would have been a suit against the individuals responsible, not the state as an entity. The state can't be liable for these sort of things. The court found the department liable for the actions of specific officers without proof of systemic policy failure. Vicarious liability requires a showing that the negligence was a result of a departmental policy, not an administrative slip-up. And the warrant update, which was performed by CID lead Dante Valentino, was a discretionary act of due diligence to add supplemental evidence and not a policy violation. The judgment against the state should be vacated because the wrong defendant was sued, essentially.
Is that everything?
No, sorry, I thought I was talking for a moment there. The plaintiff can't claim to be the victim of state negligence while simultaneously being adjudicated as the perpetrator of fraud.
Baz, what are we doing? Yo, what?
Her status now as a convicted felon who fabricated her authority undermines any claim that that the state's actions were the proximate cause of her alleged injury. The truth is that she created the reality that claims hurt her. In terms of damages, the court awarded $8,000, which is almost double the amount of her actual expenses that she incurred as criminal fines. And it kind of functions as an unauthorized punitive penalty. There was no testimony or medical evidence or expert opinion that quantified any sort of emotional harm that should have been awarded damages. And the court erred when it arbitrarily assigned a number. In a negligence claim, the damages must be proven with the specificity, and just a feeling of inconvenience does not justify an $8,000 payout, which I will point out, counsel did represent to the court earlier that this was small claims court. I believe $8,000 is above the stated limit for small claims, so that would make this actually a large claim.
You did say small.
So the damages are basically legally
Vance made an exception.
Probably be reversed. Whether with the criminal finding of fraud, any claim of emotional distress arising from her arrest is further negated. You can't claim that you're distressed at being arrested for a crime that she actually knowingly committed. And the award of that $8,000 functions as an unauthorized penalty against the state
needs to wrap this up.
Necessary for law enforcement in response to a known deceiver. And catch and release, especially when court charges are on the docket, is pretty standard when it comes to operating procedures.
God damn. Did he take a breath?
Counsel argues that this is not a valid warrant. We can look at the warrant. We can see that there's reports. We can see that there's testimony there. There's witnesses, which definitely had probable cause at the time to create the arrest. They chose to release her because CID was not there to handle the specific supplemental court charges, and this was a lawful exercise of their discretion.
I'm literally lost. I'm checked out.
And it was not an error. Miss Love was going to get her day in court, and the warrant she surrendered to, and it was a formality before trial could be had. Her immediate rearrest in court confirms the warrant was valid and the process was sound.
If I'm Aristotle, I'm literally checked out right now.
The officer's decisions to wait for CID was prudent, and it was a safety measure to prevent her from accessing
Objection
purposes.
too long.
Releasing her to await proper authority was the correct action, not a negligent one. And the civil bench trial was held while
no, you can't object to opening statements.
Making premature determinations on facts, specifically intent, validity of the arrest, and these are now contradicted by the final criminal judgment. And to allow the civil judgment to stand would create a direct conflict between the civil and criminal rulings regarding Ms. Love's intent and the legality of the arrest itself, which at this point has been adjudicated and is decided on with prejudice. So the civil judgment was built on this factual foundation of negligence that the criminal appeal has shattered. Ms. Love is not the victim of an administrative error. She's a convicted impersonator who knowingly deceived public law enforcement, and the state should not be liable for the consequences of a citizen's own criminal fraud. So we request that you dismiss this and reverse the judgment. Thank you, Your Honor.
God damn.
Pardon.
Your Honor,
Suarez.
we would like the motion to offer the plaintiff a water bottle from all that yapping, Your Honor.
Yeah. Extra
I'd love that.
breathing.
Yeah, I need to
Objection.
breathe.
Too long, Your Honor.
Well, I didn't have witnesses, so I wanted to make sure I got all my points out there.
I'll
Thank
be
you very
honest,
much.
I've heard longer, Mr. Suarez. And
God
Yeah.
damn.
if you can't concentrate for that couple of minutes, I don't know what's going on. Your response, please, Mr. Suarez.
Sure. Yeah. So that was his motion or his opening statement, I'm assuming.
That was his motion.
Sure.
It's both.
Motion
That was the-
It was
it's
both?
both? Okay.
Well, plaintiff
Yes,
was saying it
because
was
I
both.
have no.
It will be his argument as well. If I do not dismiss the case, that will be his argument.
Sure.
If I
Yeah.
decide
So
to dismiss the
basically,
case, then
argue
it'll be
against his
over now.
motion.
Yeah. We're definitely gonna object to any motions about dismissing the case, Your Honor. The evidence will show that. I'm gonna just TLDR it for you. Cop wrote warrant. PD accepted warrant and activated warrant. And cop arrests Miss Love. Cop look at warrant. Warrant is bad. Cop realized they fuck up, and cop let go Miss Love. And then cops get sued for administrative negligence. He'll say that we had a limit, and it was small claims court. To touch on that, Judge Vance already acknowledged this previously, but he made an exception for this case and increased the small claims limit to $15,000 for that. So just gonna note on that about plaintiff's objection on the amount and the monetary value. But yeah, please just ultimately we're gonna object. The evidence will speak for itself. We have photos of what the report looked like. The cops fucked up. Pardon my French, Your Honor, but the cops made a mistake, and we as the defense ask that they continue and stay punished for it. So we're gonna object, Your Honor.
Okay, I'll be perfectly honest. I'm going to take 5 minutes to have a look through what's going on with this and I'm going to consider what Mr. Barley, what Mr. Suarez said. So I'm going to adjourn the court for 5 minutes. I'm going to go back to chambers and have a think about this motion. And I will come back with an answer for you very shortly.
All right.
Think about this motion.
Huh?
He said, think about this motion.
Oh, buddy, why are you writing a
Exactly.
20-minute opening statement, man, for this appeal?
Because I don't have any witnesses here today, so
You-
I
you
needed
need
to
like
get all
a-
That
my
was your
points
motion,
out.
An
that
oxygen
was-
tank? You took
I
all the
know.
air in here.
Yeah, man. I was
I
you
thought-
know confused. You know what I mean? I was like, I was talking to Hazel. I was like, maybe you need a water bottle for all this fucking yapping you was doing, man.
No, absolutely. It was long-winded, but I figured I'd get it all out at once, and then we can go home.
Oh,
Okay.
Thank
You
you.
Hey.
deserve that.
you're gonna go home. You're gonna owe us some money, all right? You're gonna go us and Miss Love some money, all right?
We'll see. We'll see.
If Aristotle
Oh
dismissed the
my
case, bro, I literally can't be asked to like. I'd be
whatever.
just.
It
The
just
report
makes
is literally
it
practically
faster.
empty. The report is literally empty. So if he goes and he looks at the fucking report and he sees the evidence and he sees there's no linked vehicles, no linked properties, no photo reel, no attached lab reports, no evidence locker, and all the witnesses are listed as they still need an interview, so no witness statements because they're not interviewed, and then there's no like in the base of the report the evidence is literally empty. There's literally nothing under the evidence as to why the pressing the charge. The only thing that's in this report is the definition of what the charge is and very, very light remarks about the burdens that she's meeting with no evidence to press an active warrant with a probable cause.
This is why I wanted you to mention that the criminal trial was separate from this arrest.
All right, well, I mean, you think the dad is good? So you think without
I
mentioning
don't
that he's
know,
gonna dismiss
man.
this case?
You never know with these guys.
Oh,
Text him
well,
real
maybe
quick.
that's what the case is about. He's just motioning. You know what I mean? If he wants to hear the case, he should just deny the motion. I'm not sure why he's taking 5 minutes to review it.
There's no duty
I don't know.
warrant.
To see if it's worth it or not. I mean, hey, if he dismisses it, whatever. We were over this, you know?
I mean, yeah,
We're
but
done.
he shouldn't
We're done with the
dismiss
love.
it without hearing what exactly transpired. You know what I mean?
Doctor, you got a first aid kit? I got a boo-boo.
Yeah, no
Oh
problem.
my god, that's because you're such a boo.
Tom, please.
Sorry, professional, my bad.
This is why I changed my clothes before I came here.
Thank you very much.
You're so tall.
I know, I'm very intimidated.
Never been more happy.
I feel so small.
He probably wonders if you're a dummy, mommy.
Okay, I'm sitting down now. Bye, man.
I've got a husband.
Trust me.
No,
I
this is
know.
dismissed. That means that the appeal
Hey,
is.
if he bothers you, just let me
void.
know, okay? Let me get your
I'm his
number.
I'm his doctor. Don't worry.
Exactly.
Where's your husband?
I'm his wife, so I think Peanut.
Oh,
Unfortunately.
Peanut. Oh, yeah. He's a therapist now. Cute.
I don't think
Well,
we
he's a-
want.
he's a
No, we
health
don't want him to
coach.
dismiss.
Yeah, he's not a therapist.
Okay,
Oh,
sorry. Health and wellness coach.
He's not even that. Do not
Jim-
take any
and-
advice from him.
Jim just appeared out of nowhere.
He walked
Just
over.
like a
Damn.
magician.
I just came from. No, I'm not a magician. I commit like
I did
retired.
not see you come in.
You can
Commit.
No, we didn't see you. All of a sudden, you were just there.
Just here.
Oh, I forgot to say, Mr. Suarez.
Yep.
Just to let you know, there was someone dressed up as you earlier. Same beard, in a logistics outfit. They came into the hospital, but it wasn't you.
Really? Someone was dressed up as me? Who the hell is dressed
Yep.
up as me?
Yeah, they said they were Alex Suarez, but they weren't.
Are you sure? Cause like he has twins. I've literally
No,
met a twin.
no,
of
no.
him.
They.
I
literally
definitely
said they
wasn't
were
at the
Alex
hospital in my
Suarez.
logistics outfit today.
They came into a therapy session and then they got kicked out because the person said they weren't. They weren't.
They can't. Who was the therapy
Alex
session
Suarez.
for? Or who was there?
Well, Peanut was leading it, and it was for someone else, which I can't discuss the patient, but they were dressed exactly like you. It sounded a bit
Hey,
different.
what's
though.
up, Suarez?
Yo, Peanut. Was there a fake
Yeah, what's wrong?
Suarez in this fucking therapy thing?
Wait, what?
Was there a fake Suarez in some therapy session this
Hello,
morning?
this is Jim.
In a therapy session? What you mean?
Therapy session this morning.
Fake Suarez?
Yeah.
No, I don't think anybody could ever copy me in a vegan like you.
Yo, buddy, I wasn't there, man. So who the hell dressed up as me?
I don't know. I don't know, to be honest. Actually, now that you say that, some random motherfucker did come in looking exactly like you into my therapy session with a Viper, and then he just walked out. It was fucking weird.
Okay.
Maybe your brother.
I need to post something.
Okay.
Maybe
My
your brother.
brother. That's
Something.
definitely not my brother. Okay.
Well, but yeah, so I thought it was you, to be honest.
All right. What's Viper getting therapy for?
She basically said she needed a father in her life. She has no father.
What
She needed
the
my help
fuck?
trying to get a dad or something. I don't know.
Your
freaky
help
shit.
getting a dad.
Oh, Hazel's not
Well,
happy.
Really?
Well, hold on now. Hold on now. I'm a
Really?
therapist, baby. I'm a therapist.
Really?
I'm a helper.
Okay, no, it's okay. I'm gonna help old guys get a mom.
Oh.
Thank God. Now we're talking.
As long as you're not the
Oh.
mom, it's fine.
Oh yeah? You're not the daddy?
What? What the fuck are you? No, I'm not the fucking daddy, bro.
Wait, you
I'm
weren't
a
trying to be Viper's
therapist, don't
dad?
No, I wasn't.
That's what it sounds like. I'm talking to the doctor right now. He said that's what you were trying to do the whole case.
What doctor?
The doctor. The doctor who was there for
What
the therapy
doctor?
session.
Your
Doctor
It
doctor.
doesn't
Helms?
matter. It doesn't matter what doctor. He's just saying that you was very intentionally trying to get Viper, to be
trouble.
your daughter. You know what I mean?
No, I was not, but she's lying there.
No, hey, doctors don't lie, man.
Interesting. Very interesting, Peanut.
I don't know, Peanut. I don't know,
She's
man.
lying. I'm telling you the truth. I didn't do shit.
All
I
right.
was not trying to make her my daughter. What the fuck?
Also, all right, man. All right. Well, we're doing a trial.
What's going- Also
So.
what?
No, nothing. I'll talk to you about it later.
All right, we'll talk later. Let me know.
All right.
Why is it every time you answer the phone, it's always on speaker? I feel like it's only you.
Oh, I definitely put that on speaker intentionally.
Oh, okay.
More fun that way.
Yeah, there was definitely a fake you running around. He said he was vegan, so.
Yeah, not vegan, vegetarian.
Yeah, he's vegetarian. Maybe you do have a twin who's vegan.
Oh, you're right. I forgot.
Did the
Well, I
exact
already
same
forgot, so I can't remember right
Yeah.
now. That y'all reminded me, chat.
Hell no.
thing. Oh.
What are you doing here? Doing court?
You a
I'm a lawyer. Yes, I am.
Oh my god.
I could say the same about you.
But I'm not a lawyer.
This is
No,
a
you're an
great view
EMS.
from my angle. This is a great view, guys. You just stay where you are.
What the hell?
Ignore him.
He's looking at your ass.
Doctor, I'm gonna tell Peanut.
That's fine.
It's
Well, a
Suarez.
man can admire from a distance.
If you know any women that are like dummy mommies, Dr. House is looking for one.
How's it going, boss?
Is she really a lawyer?
He is, yeah.
I can track the
Oh.
vehicle.
Hey, what's going on? You can track the vehicle? Can you get cops on it?
Yeah, I can track the vehicle. Yeah.
Okay.
It's my truck.
All right. Track the vehicle. Call the cops and then track the vehicle and get them and have them chase it down. All right.
Yeah.
All right.
Yeah.
All right. Call 911. All right.
Yeah.
He's like, yeah.
I was unsure. Should be quiet.
'Tis me.
Yo, if Aristotle dismisses this case, bro,
What are you guys doing here?
I'm gonna be a little
What do you do
disappointed,
here?
Chad. To be honest, man.
Came to watch a court case.
It's definitely
What
unlawful.
case is it?
Appeals.
It's the appeal of that law.
He said lookalike stole his truck. Yeah.
I changed my clothes so people wouldn't ask me for, medical
So it's
help
probably Gio and Jizzle.
while I'm not on duty.
But now I'm gonna ask if I see you. But I'm not gonna ask about medical. I'm gonna say, "Hey, Miss Pope." That's what I'm gonna do.
Okay. Back. Sit down. Sit down.
Oh.
Back.
Right, ladies and gentlemen. Having reviewed the motion to dismiss filed in the above captain matter, together with the submission of the parties and the relevant procedural history of this litigation, court
I am
now
lost.
delivers its ruling. Court finds that the motion to dismiss must be upheld. In reaching this determination,
Holy moly.
the court has considered the factual record presented by the state, including the findings and determination previously rendered in docket case number 31. The record demonstrates that a guilty verdict was entered against the defendant in that proceeding. The court further finds that this determination was subsequently reviewed at appeal docket 30, wherein the appellate tribunal upheld the prior findings. The court additionally finds that a significant procedural irregularity occurred in the related civil proceedings. Specifically, the presiding judge failed to allow for the statutory amount in the small claims jurisdiction threshold and raised this to $15,000. This materially affected the handling and disposition of the claim and contributed to the procedural deficiencies now before.
Holy fuck, bro.
Taken collectively,
I'm annoyed.
Taken collectively, the court concludes that these errors are not merely technical in nature, rather they constitute a grave error in the administration of justice. The combination of a judgment entered against the wrong defendant, the subsequent affirmation of the error in the appeal, the subsequent affirmation of the conviction on appeal, and the failure to apply a correct small claims threshold undermines the integrity of the proceedings and deprives the present action of a legally sufficient foundation upon which relief may be granted. Accordingly, the court finds that dismissal is warranted with prejudice.
Thank you, Your Honor.
Your Honor, did you see the report?
I wasn't looking at the report to start with, Mr. Suarez. It was
I mean, yeah, but that's also pertinent to hear the case,
Mr.
Your Honor.
Suarez, please let me speak. So I was dealing specifically with the motion to dismiss. You didn't argue against the motion to dismiss the part thing.
How did we not argue against it? We literally objected to his argument.
You objected to the argument with no facts.
We explained
Again,
that the
Mr.
cop
Suarez,
wrote a
my
bad
decision
warrant,
is final.
cop arrested.
My decision is final.
Yeah.
I'm not here to argue this decision.
Yeah. Well, you could have heard the case, Your Honor.
There was no warrant for the case. You argued. You didn't argue.
How was there no warrant for the case when so officers can just write a bad warrant,
Mr.
activate
Suarez,
it, and there's no negligence? No, I
Mr.
need to know,
Suarez,
or we can go talk
I'm
privately.
going to sanction you if you do not shut your mouth now. Thank you.
All right.
In your argument, which you were given a chance for, you were offered the chance to argue against the dismissal. You chose not to do so. That is on you, sir. Next time you see Mr. Suarez.
It makes no sense. All right. Sign off duty. So cops can just write bad warrants with no evidence in it, activate it, and there's no wrongdoing. All right.